This presentation looks at some of the legal issues connected to creating and distributing your media. This short presentation should not be seen as definitive in its approach to legal issues, but should act as a guide to give you some information in key areas that you should consider when creating your work. When you create media, it's important to stay within the laws of copyright. This guide will mainly look at the key areas of copyright and how they apply to you as a media creator. In addition, it will also offer some guidance about location and appearance permissions. So to start with, what is copyright? Copyright is a legal framework that protects your work and ideas once it's been created. So why is copyright important? Rules about copyright are law, which makes it quite important. Copyright law sets out how types of creative work can be used. It sets out the rights of the owner of the creative material, as well as responsibilities others have if they want to use any of that work. Infringement of copyright is a criminal offence, and in the most severe cases can carry a prison sentence and a hefty fine. So having an awareness about how copyright works and what's allowed is pretty useful. What is protected by copyright? Copyright protects works but not ideas. For example, a book can be copyrighted, but the idea that that book is based on cannot be. Works that are protected by copyright are any literary, dramatic, musical or artistic works, as well as films, sound recordings, book layouts and broadcasts. How long does copyright last for? The length of copyright depends on the type of work. As a general guide, for written, dramatic, musical or artistic works, copyright lasts for 70 years after the author's death. For sound and music recording, copyright lasts for 70 years after it's first published. For films, copyright lasts for 70 years after the death of the composer, screenplay author, and director. For broadcasts, copyright lasts for 50 years after the item was first broadcast. For layouts of published editions of written, dramatic, or musical works, copyright lasts for 25 years from when it was first published. So when is something copyrighted? Whenever you create an original work, you automatically hold the copyright for it. If I do not see a copyright symbol on something, does that mean it's out of copyright? No. There is no requirement to put copyright symbols on works, as copyright is an automatically assumed right. Sometimes people do this to reaffirm that their item is copyrighted. But it's not a requirement. And that means anything published or produced should be assumed to belong to someone. And as such, permission should be sought from the creator before using it in your media. How do I avoid infringing copyright when producing work? There are several ways in which you can use material in your work which avoids infringing copyright. These can be divided broadly into three categories: public domain use, licensed use, and copyright exemption use. Public domain and the licensed use are the simplest ways of using other people's material. When using the copyright exemption use, an argument needs to be made on a case-by-case basis to justify using any of the material. Let's look at each of these in turn. Public domain. Public domain is a very misunderstood term. It does not mean that you are free to use anything that has been produced for public consumption, such as items released on YouTube. It means that the copyright for that work has lapsed, and it can now be used freely by anyone. However, this may be hard to verify, and in addition, you may not wish to use items in your work that are so dated. Licensed use of copyrighted material. This means that you have been granted permission under certain circumstances to use others' copyrighted material in your project. Two of the most common licensing types are Creative Commons licensing and royalty-free licensing. Creative Commons. This is a good source of material and has been released under Creative Commons licensing. Creative Commons licensing doesn't mean the material is copyright free, but that the creators have allowed others to use the material, provided certain criteria are met. Different material under Creative Commons are released under different licenses. So read these carefully if you use any. The main licenses are attribution, where you need to give credit for using the work. Non-commercial, where you cannot use the work for commercial purposes. No derivative works. This means that you cannot change or remix the work. This includes video editing. Share alike, You can use and remix the work, but only if you do so in work which will also be released under a Creative Commons license. Royalty-free licensing. First of all, royalty-free licenses are not free. What it means is that you purchase the rights from a vendor to use copyrighted pictures, pieces of music, or video clips in your project however you see fit. Depending on your audience and if you intend to make money from your work, it can affect the cost of royalty-free material considerably. Some websites exist which allow you access to their archived content of media for a single subscription fee, such as VideoBlocks and SoundDogs. Exemptions to copyright. In 2014, there were changes to copyright law, which clarified occasions when copyrighted material could be used by others without requesting the owner's permission. For details on all of these changes, please visit the copyright website. A notable exception that can apply for the use of copyrighted material is a term called fair dealing. Fair dealing is a legal term used to establish whether the use of copyrighted material is lawful or whether it infringes copyright. There is, however, no statutory definition of fair dealing. It will always be a matter of fact, degree, and impression in each case. So always seek appropriate advice when wanting to use copyrighted material in your work. Fair dealing almost always requires that any work that you wish to include copyrighted material in is not used for commercial purposes. Fair dealing can also be argued for materials used in research and private study. You are allowed to copy limited extracts of works when the use is non-commercial or it's used for research or private study. But you must genuinely be studying that subject. Copying the whole work would not generally be considered fair dealing. The purpose of this exemption is to allow students and researchers to make limited copies of all types of copyrighted work for non-commercial research and private study purposes. Fair dealing for criticism, review, or quotation is allowed for any kind of copyrighted work. Fair dealing for a work with the purpose of reporting current events is allowed for any type of copyrighted material except photographs, and in each of these occasions a sufficient acknowledgement of the source of the material would be required. In addition, the copying of works in any medium, so long as the use is solely to illustrate a point and is not used for commercial purposes, accompanied by a sufficient acknowledgement, is permitted. However, reproducing copyrighted works which would undermine the sale of the original works is not permitted. If you are in any way unsure about the use of copyrighted material in your work, then seek advice before use. Some final thoughts on additional legal issues when creating media productions. Performance rights. An important point to remember when creating your media is performance rights. It is important to get your subjects to sign a form so you have legal proof that they have agreed for their image to be used in your video or production. This should set out clearly what their image is to be used for, and materials should not be used for purposes outside what is on the form. An example of this form is included in the additional notes in this section. This applies to anyone who is a focal subject of your video. It is also worth noting that those 16 or under require the signature of a parent or guardian. Production on location. When planning your video, also think about whether you have the permission to film in the location you're in. Despite some media reports, it's not illegal to film in most public places. But be aware, you may be challenged if your behavior seems suspicious, or you're recording something that may cause particular suspicion. For example, if you're recording something like a fight scene for a drama, then alert the local police so you do not cause any false alarms. In private locations, you will need permissions from the owners. Some places that seem public can actually be privately controlled, and you will need permission to film there. This can include places such as shopping centres or pavements outside shops. Do your research before planning to film in any particular location. When on location, also think very carefully about what you're doing, and that it doesn't pose a danger to the public. If anyone gets hurt due to your carelessness, you may be liable. These are just a few of the legal issues involved in creating media. With a little common sense, they're relatively easy not to fall foul of. There are further details and advice in the links in this section.